All right, welcome. My name is Chris Brock. I'm the president of the CU Law chapter of the American Constitution Society, along with ACS, the Byron White Center for the Study of American Constitutional Law, and the Colorado Bar Association. Welcome you to an evening with Chief Justice Michael Bender. The Chief Justice is retiring in January, so we were looking for a way to honor him for his many years of service to our school. To our state. Not only is he alumnus of the best law school in the state, the Chief Justice has served Colorado as a public defender, a private attorney, a professor, and a justice on the Colorado Supreme Court. So we decided that the best way to honor him is to actually sit down and talk with the man himself about his life and his years of service to the state. So without further ado, I welcome Professor Melissa Hart, the director of the White Center, and the Honorable Judge Terry Ruckriggle, President of the Colorado Bar Association, with the Honorable Chief Justice of the Colorado Supreme Court, Michael Bender.
So, is this working?
We're on?
Yeah, I think it is.
Okay, now we have to watch ourselves.
I want to first, before we get started talking, thank Chris Brock for suggesting this program and thinking about ways to get people here. It's always a challenge, I know, for folks from Denver to come to Boulder, and the construction has made it even more challenging. So I really appreciate those of you who came up from Denver and the students and people from the Boulder community who are here as well. And thank you so much, Chief, for spending this time with us. Judge Ruckriggle and I have communicated for a total of about a minute on how we're going to divide this up. But interestingly, when we sat down to think about questions and we sent each other a list of questions, our questions were different, but I think overlapping in interesting ways. And I think if it's all right, I'm going to start with a question that I think I like that. I'm curious what advice you would give yourself if you could go back in time to the moment before you became a justice and say, here's something you need to know that you now wish you had known earlier and that you had to learn through hard work along the way.
To be a what?
A justice. Either a justice or the chief.
Well, I think probably the most difficult thing for me was to recognize the relationship between the law clerks and the justice. My experience as dealing with lawyers that work for me or associates was I would just give them a direction and they would do it, and I'd tell them what to do and how to do it. And the reason I did that was because I didn't have enough time to do it. And the relationship with my law clerks was much more rich. I learned as much as they learned from me. And it was, I hate to, some of them are here, but it was really an intellectually intimate relationship. And so that was the one thing that I found the most, I guess, different, that I was the aspect of the job that I was totally unprepared for was really thinking about working with law clerks in a different way, working on opinions, getting their ideas, and being challenged myself in ways that I just wasn't, I didn't anticipate, and it was great. I loved every minute of it.
For those people who have worked in the court system before, probably everyone has their own sense of this, but when people from the outside think of who your colleagues are, they think of the other justices. Mm-hmm. But in some ways it sounds like you're describing the collegial relationship of the clerk and judge as at least as central.
That's true. I think you asked me what did I learn the most, and that's why I said that. But it's also true that not with all the justices, but with some of the justices over the years, there was terrific collegiality, and we constantly challenged ourselves on many issues, and that was great. And I kind of anticipated and hoped that I would have that experience, and I think I did. But the one that I was totally really unaware of was the law clerk relationship.
I'll start with a softball.
They're all
What do you think?
softballs, Terrence.
What do you think the most important opinion or decision that you wrote was?
Because you asked it, I would like to say the dissent I wrote in People versus Bryant, but I won't.
I figured you might do that.
A prior restraint. No, I don't think that was the most important opinion. I think the Lobato dissent was the most important decision that I've written. And the reason I say that is there are a lot of cases that either on a majority or dissents which affect a small number of people, but or the individuals, and certainly that's significant. But I think that the future of Colorado depends on public education, and the trends and what's happening in this state is absolutely drastic. And I think the Lobato case, the facts of Lobato, bear that out. And I think that's by far the most important case I've ever written.
Along that line, since we agreed that we could follow up on something, it's interesting, when I was interviewed for the Supreme Court back in 2000, a question came that sort of threw me off, and that was, what do you think is the importance of dissenting opinions? And since you've referred to a couple of those, what is the importance of it?
I guess I had a different philosophy. Well, first of all, people should know that Terry was one of 3 people that were selected by the commission in 2000 to be on the Supreme Court, and he wasn't actually chosen. He was the chief judge in the 5th Judicial District in Breckenridge. But I think that, my philosophy was not to write my philosophy. My philosophy was only to dissent when it was really important. And some issue that I found that I dramatically and seriously disagreed with the majority. And as a consequence, I haven't written too many dissents, although in the last 3-4 years I've written many more dissents than I have historically. And I think it's pretty important to have, on the state Supreme Court, to have a majority opinion that lays out what the problem is, for the litigants, for the public, and for the lawyers. And there's multiple audiences, I think, an opinion has, and it should be clearly written and reader-friendly and so forth. And I don't think that concurring opinions or dissents, unless they're on very important issues that have some overriding value, should be part of it. It's not. I didn't take the job to write my philosophy of law, period.
I want to follow that up, actually, and ask, do you have a sense that people outside of the law understand the court's opinions and understand what the court does and what the justice's role is?
I think it's very limited. I think that most general public and the lack of civic education is rampant in the country, and certainly in this state. It's no exception. I don't think that people understand the role that an independent judiciary plays, and they certainly don't understand the role that a Supreme Court of a jurisdiction, statewide jurisdiction, plays. So no, I think there's very limited understanding, and I think very few people read opinions, and maybe most lawyers will look at an opinion when they have a specific problem, but not even. I mean, I've many times gone to bar groups and sat next to lawyers, and they had no idea who I was, before I was Chief Justice. So, I think it's a serious problem. I think it's one of constitutional dimension, that to have a system which should be a co-equal branch of government, and it clearly is not in the public's eyes. And because we don't have a requirement for civic education anymore in high school, and because of the lack of willingness, frankly, some of it is brought on by the judiciary. The judges themselves don't like to get out. They don't like to explain to people what they do and how they do it. The judges aren't perceived as human beings with trying to deal with and grapple with very difficult problems. And in my view, I think that's part of the issue, part of the problem. So I think it's very, very, very serious. There's no media reporting of what goes on in either the trial courts or the appellate courts. except for some sexy, very serious murder case or case involving celebrities. There used to be regular reporters. There's just very little awareness of the role that the judiciary must play in resolving disputes in the constitutional framework.
And so you just suggested some things, I think, but do you think there are things the judiciary could be doing
Oh, yeah.
to contribute to
Well, absolutely. I think that one of the problems is that people who want to become judges tend to be, especially in Colorado, where you have merit selection system, they're not extroverted. They don't like to go to community events. They're very good. They're hardworking. They're honest. But they have they're not comfortable outside the courtroom. And I think that's very bad. I think that the whole purpose of a judiciary is to serve the legal needs of the community and to be aware of the community needs, whatever we're talking about. And we need to do more of that. Now, we used to hide behind canons of judicial ethics that said you can't do any of these things, which is now, I guess, diminished. But there's still a tendency not to do that. So I think to some extent we're responsible, but the legislature used to be made up of a lot of lawyers. There are very few lawyers in the legislature, which is a reflection of the attitude of the public and the education of the public.
I do feel like I have to point out that I'm sitting between two judges who are very active in going out into the community. So there are some.
That's right, but it's not many, and it's people that have to be prodded, and I've tried to prod them, to be honest with you.
Back on the issue of cases.
Dissents?
No, not dissent. But some of the Colorado Supreme Court cases, during your tenure, did go up to the United States Supreme Court.
Just one.
And I was going to ask you to comment on that. Okay, I thought there were two, but
no.
Which one?
Bubble case.
Yeah. So I was going to ask you to comment about that.
I don't remember the details. Maybe Melissa
For people
does.
who don't know, the case you're referring to Hill against
Yeah.
Colorado. This is a case, actually, interestingly, that the Supreme Court this term is considering a case that may
Reverse
this case. This is a case called Hill against Colorado, which dealt with a state law that created a bubble around
Abortion clinics.
and said that a free speech or a free speech free zone that said you can't approach people going into clinics within 100 feet. You have to stay at least 8 feet away from them, I believe is what the law said.
Yeah.
And the Supreme Court said that that was constitutional because it allowed that approach up to 8 feet within the larger bubble. And the case that the court has this term is a different law. It's a Massachusetts law that has a 35-foot bubble, but with no interior
Oh, I
bubble.
see.
So it's different, but people wonder if it may overrule.
Yeah, that case was affirmed. Greg Scott wrote that opinion. I don't even think there was a dissent at the time. I don't remember from our case. That's the only case. There's another case pending that we have, which is a technical airlines case, an FAA kind of thing, which is not really, doesn't have the appeal that the bubble case does.
When you're writing opinions, not just you, but your court generally, all of you, do you think about the possibility of the case being taken to the Supreme Court?
Not too much. I can't say that I did. I think when you have an opinion and it deals with federal constitutional issues, that you're aware of what the Supreme Court says, and we're bound to follow them on federal constitutional issues. And we're aware if we get a case that we may be deviating in some fashion based on the Colorado Constitution. But I haven't felt myself any tendency to resolve a case in a way that they might not take or they should take or something like that.
What is your fondest memory about when you were in practice, when you were an attorney before being a judge? What did you like about that? Practice or PD, any of that?
I enjoyed, the thing I missed the most when I became a justice is really giving advice to people and trying to resolve problems, usually in the context of litigation. But there's an egotistical, they pay you a lot of money and you tell them, well, I think you might do this and do that, and you try to do a course of action. There's a sense of power and feeling of, and I missed that aspect of practice. And I really liked that a lot. You know, and I had a lot of wonderful highs as a lawyer, and I'm hoping for a few more still to come. I think that the things I enjoyed the most were the little things. We're helping somebody out, talking to someone at jail, helping a kid that had a little problem, helping sometimes a big executive that had a little problem. I got his hand caught in the cookie jar. Resolving a case, a complex case, in a simple way. You know, as well as occasionally doing okay in the courtroom. But it wasn't just, you know, being a hotshot. I mean, I didn't mind doing that if given the opportunity. But I think it was the human interaction and the satisfaction of trying to help someone solve a difficult problem.
You did have some good cases, as you referred to it as highs. Anything in particular that you would
Well, I
share?
think the most important case I did was when I was a very young lawyer, where I represented 3 women, a black applicant, a Hispanic applicant, and two African American applicants, actually, who were barred from even taking the test to be a cop in Denver. And that was because they didn't have women. And we had a class action. Judge Araj, to his, reluctantly certified a class. And then after a lot of hearings, a lot of depositions, and a lot of hassling, he finally declared unconstitutional the testing system that they used, and issued basically kind of a quota system, which is still in place today for women and minorities going into the police academy. And I think that's probably the most significant case. And he got a lot of hate mail for that. And anyway, I only think I've been a lawyer 4 or 5 years.
How did you end up with that case?
I knew one of the city councilmen, and the people came to him and said, hey, we want to be cops. We can't get through the front door. And we had 1 black cop and 1 Hispanic on the force. That was it. At that time, it was about 1,500 police officers in Denver. So he sent it to me, and I filed the case, and off we went.
Was that the first class action you had ever done, I assume?
Yes.
So one of the things that my students often are scared about is that they will never be able to be competent to practice law because they don't have a chance to try everything before they have to do it on their own. And I'm curious what advice you would give to future lawyers or young lawyers about sort of leaping into something you've never tried before.
Well, you know, at that time, I had probably tried, I don't know, 50 to 60 felony cases. I had probably tried, I don't know, 10 or 11 civil cases. I hadn't done any class actions, but I sought out a lot of help about civil rights cases. It was a 1983 case. I'd never done that, but I mean, I didn't just go in and federal court and file a complaint. And, you know, I had a lot of support, and so I made a serious effort at finding out about how you do this. And those cases were just starting. It was one of the first cases. This is 1972, I think. It's a long time ago. So my advice is you can't, you know, if you have the litigation skills, you have to recognize what you don't know and get help and try to get support for that. So I had people from Washington helping me that either used to work for the EEOC and that sort of thing, or national employment lawyers.
you've had experience in both state and federal courts, and how would you, what would you say to lawyers about practicing in state and federal? Should they try to do both?
Sure.
Is that?
I mean, there's no difference. It's just that you have more of a silk stocking atmosphere in federal court. Judges higher up, you know. I think you have to pay a lot more attention to a federal case than you do in state court because they don't have as many cases and they have more people per case. Judges, I'm talking about more resources. But hopefully, with the new CAP program that's in Denver, there'll be more attention to each individual civil case. But I don't think there's really any difference. I think if you try cases, if you have experience, you know, it's the same thing. You're dealing with opponents, you're dealing with judges, you're dealing with juries. The settings may be different, but I don't find too much. And you have to understand the rules. You got to know the unwritten rules as well, which they don't teach you in law school.
Well, that kind of goes to the rest of the question, which is difference in terms of the experience with judges in federal versus state. Do you not find any difference
you
there?
know, I practiced for a couple of years in front of a man who died a long time ago, Henry Santo, and he was as much a stickler as any Article III judge that I ever appeared in front of. And, you know, it depends. There are other judges that were pretty loose. I handled a case in Philadelphia where the judge never came out. I dealt with his judicial assistant on the record and everything. We did the whole case. He just signed documents. I think you have to be ready as a lawyer to deal with whatever the situation is. You can't predict exactly what happens, at least in litigation. And that's the beauty of it. That's the bane of it as well.
So you just referred, I think, to the pilot project in the civil courts here
Yes.
in Colorado. And one of the things that I know from academic work and procedure is that all national eyes are on Colorado right now because of that civil pilot project.
Right.
I'm curious, I realize it's early yet to pass judgment on it, but are you willing to?
No.
Oh my gosh, it's like Justice O'Connor is here.
No, I mean, the reason I'm not is I've written opinions praising it. I mean, I don't think there's any question, and I'm sure Judge Ruckriegel will agree with me, that a trial judge ought to manage the case and to do it personally and get involved in the case and deal with the issues, whatever the problems are, whether it's a criminal or a civil case. Now, whether the specific provisions of the CAP program are the answer is another question. And so I think that should be determined. I've talked to people, you know, they'll come up to me and tell me, geez, it was the worst thing that ever happened. On the other hand, I've had lawyers tell me it's the greatest thing that ever happened. So I don't really know. I'm sure that aspects of that CAP program will be blessed by the empirical study, and probably there'll be some other changes that have to be made. But and it really depends on the judge. That we didn't need a CAP program. A judge under our existing civil rules could do a lot of these things if they wanted to. So this just gives a little onus to get judges to really manage cases and to cut down on discovery and not let lawyers just do things, whatever they want to do. That's all.
So I was just going to ask you if you were willing to describe for people who don't know what it is, what the program is, but I think you just did a pretty good job. It's essentially a...
Well, there's some very experienced lawyers here in the courtroom that are familiar with it.
There are some, but there are some law students here too.
That's true.
But the basic, how it runs for one more year before?
No, yeah. Well, it'll run through the end of this year. No, 14, and hopefully in either late summer, early fall, the institute, Becky Corliss' institute, will have their evaluation of it. The main problem was to get enough cases that were comparable in a non-CAP jurisdiction from either, mainly from Colorado Springs, to compare. They had to get the right numbers so you can make a legitimate comparison of the two different types of systems.
So the idea of the project, again, for people in the room who haven't done a case under it, is that in some jurisdictions, some types of civil cases were operating under a rules project that limits discovery in particular ways, requires a faster paced resolution move to through discovery, and requires more judicial involvement in the process. And the question is that going to make civil litigation more effective and more consistent with the goals of efficiency and justice?
Well, the problem, I think, is that it's a national problem, and that is that enormous amounts of money are spent on discovery. And this is a very serious problem, I think, because it's caused a lot of distrust of the judicial system. And it doesn't fundamentally deal with what courts are supposed to do, which is resolve disputes between citizens. And so there's a bunch of little aspects to that I think will be significant. How you plead a case, when the discovery occurs, what you have to disclose, and definite involvement by the judge at every stage of the proceedings, with the lawyers and the client together. We'll see what that. It should be a good thing, and hopefully it will be. Most of it, at least.
You mentioned Justice Corliss, Becky Corliss, and you served with her for a long time on the court, and those of us who were at judicial know that there were a number of projects that the two of you worked on. I'd like for you to comment on those for people who might not be aware of that, rules
Sure.
and so forth.
We collaborated on the rule in domestic relations, 16.2. I don't know. It's basically, a lot of lawyers hate it, but it's a way of trying to do the similar kinds of things we're talking about in domestic relations cases. We worked together on revising the attorney discipline system. Jim Coyle is in the audience. He's the successor to John Gleason. They've now expanded it, but we changed the entire attorney regulation system. She and I did that. Took us a couple of years. The lawyers were all opposed to it, and then once we got it going, they liked it. I got a lot of nasty 6-page single-spaced letters telling me it was going to be horrible, but it turned out to be pretty good. And it today is a model of, I think, the system. Another thing that we did is we lobbied, this is when Tony Volokh was the Chief Justice, for the first judicial pay raise in about 10 years. And we did that together. And then we had this Civil Justice Committee. I don't know, Terry, I don't think you were on it, but which Rule 16.1, I don't know if anybody, maybe no one's used it. It's been a total failure. But it basically
We tried.
Right? Yeah.
But
It was an optional rule. It was an optional rule, and basically the theory of it is pretty much like the cap thing. It's a little better. The cap thing is much better, more well thought out. But fundamentally, it is, if we can do criminal cases where there's open book discovery and people can go to jail for many, many years, when we just have disputes about money, why can't we have more cooperation among the lawyers and the parties? I mean, it doesn't make sense. I've always said, civil lawyers treat each other criminally and criminal lawyers treat each other civilly. That criminal lawyers treat each other civilly and civil lawyers treat each other criminally. But in any event, that was a total flop. But we worked on that, and it's the only one in the country. And the reason it was optional as opposed to required. And it was for cases of $100,000 or less. And except for a few collection cases that were default judgments, it just never got off the ground. So we worked on that. Let's see. I think those are the main things we worked on. She and I did.
So your story about 16.1 raises, I think, a really interesting dilemma for reform, not just in the judiciary, but this is an example that you can recognize a problem and know that it needs to change, but coming up with the way to change in such a large and entrenched system is really difficult. So
Absolutely.
enacting a rule that's optional may not do it. Having the pilot project may be a better answer. We'll see. But I'm curious, and I'm sort of stealing one of your questions, Judge.
Go for it.
When you think about the administrative things that you've done as chief,
Mhm.
A lot of what you have to think about is what's going to be my, I just lost the word that I wanted, legacy.
Mhm.
What are the administrative things that you feel most proud of having accomplished as chief?
Well, I think that, well, first of all, you know, the judiciary is I know Obama said this, that the federal government was a large boat. But the judiciary is pretty large, too. It's 3,800 employees, over a $400 million budget, 332 judges. You know, you talk about herding cats. It's tough, 22 different judicial districts. And any kind of organization has a culture. And in Colorado, we have 22 judicial districts, each one with their own culture. And trying to change culture, you know, when I was a lawyer, we used to say, you know, to handle a case in Adams County, you have to have local counsel. So I think that changing culture is difficult. And so you have to think about it in terms of steps. And the CAP program is the outgrowth of the mistakes we made in 16.1, really. And it remains to be seen whether, and that was, there are a lot of people that think we're nuts for that as well, but the jury's out on that. We'll see. I think that for me, the most important thing that I've been able to do is more recently, as chief, is to create a spirit of looking at problems from a statewide basis rather than just a locality. And I've been able to do that, I think, by a couple of things. One is Terry was a chief judge in his district, and there's a chief judge's council that really was pretty functionalist pretty much while Terry was on the council. Not because of Terry, but because of the system. And I've tried to elevate the chief judge's council to be much more of a policy-making body and to deal with state court administrator's office in a way most people don't know. Anybody know what a state court administrator's office is, aside from people that work for me? No. They're very influential. They're the backbone of the court system. And no one ever, I had no idea what a state court administrator was when I became a justice. But they're responsible for all the IT, they're responsible for almost all the policies, for the lobbying, for putting together budgets, you name it. So they're very powerful as a practical matter, and they distribute a lot of the funds that go out throughout the state government, state judicial department. So one of the problems was in getting the chief judges to think not about just what's good for Terry's jurisdiction, but what's good for the state and how the people served. And so by empowering that group, which I think, you know, people really don't have a, you know, what we do on the Supreme Court sets maybe policy in a certain way, but every day people confront the trial judges and county court judges, district court and county court judges, and magistrates on a regular basis, and that's where justice is meted out. And so policies have to emanate from people that are in control of jurisdictions, and that's the chief judges. And that's a little complicated. But anyway, I try to give them as much more of a policy role as possible, and I think that will continue. So I feel very good about that. And part of that, to get them in the frame of how to do that, they're not used to being real leaders in their community. They're not used to being, for instance, the chief judge in the 18th, which is Arapahoe and Douglas County, has like 400 employees. Same thing with El Paso County. Has at least that, maybe a few more. Denver is a very large system. Adams County is a large system. Weld County is a large system. Larimer County, Weld is a large system. Mesa County in Grand Junction is a large system. All these are large personnel systems that have to operate to deal with people that are coming into their court with lots of problems and lots of issues. And thinking about that in a way that makes sense for all of them required a change of mind, so we have this leadership training, 10-day leadership training, which was especially, no one's ever done it like this, for the leaders, the state Supreme Court, all the 22 chief judges, the chief probation officers and the chief district administrators, and the tops in the state court administrator's office. And that has been a phenomenal experience. We're going to have our last session Friday. And I think in time, that is changing the culture. It's teaching people about themselves, what they need, how they can better serve their communities, and be more responsive to what's there, and how to deal with the people they have to deal with. I think that, to me, that'll be the most important legacy. Not any specific achievement. Of course, I like the building and the Learning Center.
You have been involved in Colorado Bar Association, Criminal Law Section, American Bar Association, and that section. What do you think is the importance of attorneys and judges being involved in the bar?
I think it's critical. I think that we, first of all, judges, law school, the academy, and the practicing bar are siloed, and that to deal with the problems that we face as a society about the rule of law, how disputes are resolved in a way that increases integrity and respect for the legal system, requires the cooperation and the interchange and the exchange of all kinds of stuff. And so I think that Colorado is very fortunate, because we have a voluntary bar, but it's Chuck Turner's here. He's awesome and has been for many years. You know, you and others have shown leadership over the years to really deal with many of the problems that face the legal profession. And I think that, so I see that as a necessity to have collaboration. And I think the law schools have to be part of it. That there's been a lot of criticism of the law schools. You know, and I think there's more to law school than simply a doctrinaire understanding and how to think, you know, in a doctrinaire teaching, a pedagogical method. But there is a very important aspect about serving the needs of community. That doesn't mean you can't make a good living, but it does mean you have to be aware of the social responsibility you have as a lawyer that being a lawyer gives you. And, you know, unfortunately, most of the people that graduate from law school are not number one in their class and are not editors of the law review, and they didn't clerk for a federal judge. But they go out in the profession and they try to earn a living, and they are responsible. They should be responsible. And I think more of legal teaching has to be directed in part at that aspect.
So I actually was going to ask, you and I have talked, and I know you talked at the law schools about the ways that you think the law schools should adapt to the changing
I think the law schools are adapting. I think change is coming, you know. It's a culture as well, slowly. But I think a lot of both law schools are making major strides in trying to deal with some of the challenges that the profession faces. Period. I mean, I think it's great, but I think it's got to continue. And that's all.
I have a recollection of one of the other administrative type things that you did, which was to be involved, and I mentioned that the other day, in getting the number of judges.
Yes. Oh, yeah.
And I wanted you to comment about that, but also that vis-a-vis the importance of the relationship between the judiciary and the legislature.
Right. Well.
And the executive.
Okay.
Open.
Well, I think it's critical. I think as a lawyer, you know, you look down at politicians, at least I did a little, and I didn't have a sense of how important it was to have resources. As I got older, and I know I see lawyers in the audience here, they'll tell you that they go to a courthouse and the lines get longer and the dockets get bigger and all that, and there's less human contact with the case. And it's every aspect sort of it's more dehumanizing than it was, say, 20 or 30 years ago. So So there has to be a way to get people to recognize the need for resources. And one of the pleasant surprises I had, coming from the practice, being kind of known as a criminal defense lawyer, although I did more than that, as being this liberal commie from New York, I was very favorably received when Justice Corliss and I lobbied for a pay raise for judges. I was kind of shocked. You know, people, regardless of or irrespective of their political perspective, they respect the judiciary. It's not, number one, on their hit parade, but it's definitely something that they're concerned about. It's like motherhood and apple pie. There are very few people in the legislature today or then that are just totally anti, judge, we get rid of all the judges, we'll be happy. There's a few, but very few. Most of them are concerned. And I found that to be, really heartening. So what you're really talking about is how can we get judges passed, And what we did before, it requires a 2/3 vote of the legislature, which is very hard to do when you have a split legislature where the governor is a different party of whoever's leading the legislature. And at that time, it's very hard to do for another reason, because everybody in the legislature was rural and they hated Denver. Denver, until about, 4 or 5 years ago, never got a new judge because it was controlled and dominated by rural interests in the legislature. And it wasn't necessarily Democrat versus Republicans. We don't like Denver. We're not going to do it. And so what we did was devised a way to get a lot of judges over a period of time so that there'd be a little bit for everybody. And so that's how we got the first 24-judge program over 24 years. But I had a harder time convincing, as you probably remember, Terry, the bureaucracy, which was the State Court Administrator's Office, to abandon their way of how to ask for judges. That was a harder task than actually getting it through the legislature, which is all part of the culture, I think, the change of culture. And people are 100% in favor of progress, but 1,000% against change.
So the side of getting judges that you're talking about in that context is getting slots for judges rather than a specific judge herself or himself. But
right.
You've gone through our relatively unusual system, merit selection system, which for people who don't know involves when a judgeship opens up or when a number of new judgeships are created, interested candidates can apply to a nominating commission, and then the nominating commission interviews some number of candidates and nominates 3 to the governor. The governor then, from among that group of 3, picks 1 to fill that slot, and then the newly chosen judge stands for retention election 2 years after that, and then for retention elections, 8 years?
Well, for the Supreme Court, it's 10 years. For Court of Appeals, it's 8. For the District Court, it's 6, and for the County Court, it's 4.
So it's really not a system of elected judges. It's a system of it's a
retention
merit selection process. But you've gone through it. I had to go through it a number of times because you were on the bench a number of times. I'm curious how you think our system works.
Well, I think it's great, especially when I talk to, as the Chief Justice, I go to a couple of these conferences, and I've developed friends from other jurisdictions, and most of them are elected. And so there's no comparison in terms of the quality of people, the kinds of issues that judges are concerned about, and so forth. So I think this is a phenomenal system. We are, the merit selection system we're the largest, in my opinion, the largest number of judges anywhere in the country, which state that has the merit selection system. There are pockets of the merit selection system. One of the weird experiences I had was about 4 years ago, we went on a tour of newer Supreme Court buildings around the country. And I was shocked to see, when we went to Michigan, I went to Alabama and Mississippi, that not only were the justices elected by the by the state, but they were elected by jurisdictions like Congress. So like a congressional district. So they have these new beautiful courthouses like ours is. Ours is nicer, but like ours. But the judges weren't there because the judges had, had their, they had their constituents they had to take care of in the locality from which they were elected. And they almost all had permanent law clerks that had been there for 25, 30 years, that obviously were doing the work. And so when we have a tour of the courthouse, maybe there was one justice that was there out of 5 or 7. It happened in 3 different places. It was like, okay, I just couldn't believe that. Another example is I went to a phenomenal thing in Montpelier as a justice. It was a small group learning about a 4-day seminar in Madison. And they had some federal judges and a couple of chief judges and some state judges, a couple of federal appellate judges, maybe about 15 judges. One guy was a justice in Supreme Court, North Carolina, and he was running for election. And they have, I think it was a 5-member court. And this seminar was in May. And 3 justices were all running for election. So the election wasn't until November, but they couldn't even get a quorum, to function because they're all out on the stump campaigning. So, and I just read it today, a flyer from the National Center today about judges and money and politics. Alabama, the guy that did the 10 Commandments, just was elected Chief Justice. He's now actually running for governor. And the former Chief Justice was really cool. Her name was Cobb, and she had spent $2 million to get in her campaign, apparently, and she decided not to run. She didn't want to raise $2 million. This particular election cost $4 million, and he made it. It's actually a stepping stone to be the governor, So there's a lot of examples like that. So I think we're very lucky to have a merit selection system.
Back to cases, besides those that we've talked about, what do you think are the important cases that the court has addressed during your tenure, the court itself, besides it?
Well, I think the redistricting cases are very important. I think the cases where we've construed Tabor are important. I think the Lobato case is very important. Lobato 1 is still important. It's still kind of on the books. Let's see. I think striking down our death penalty was important. That was similar to the Arizona, a 3-judge court. What else? Well, that's all that comes to mind at the moment.
What, stepping aside from the legal aspect of it, what is your fondest memory of being on the court, either as justice or chief justice?
Well, I don't know. I've had a lot of good memories. I've recently, I think that I've been able to instill an attitude of cooperation, not so much in result or opinions, but in happiness among the court today. I feel really internally. I feel very good about it, and I like that. We all get along. We have. I foster social events, and that kind of stuff, which we really didn't do. And I think there's a sense when I go to deal with when I traveled and met each one of the district court, 22 different districts. I did it for 2 summers. I really loved it. That was a great feeling of meeting people, talking to people, seeing what the issues were. It just felt very good. I felt very good. I think there also was a time when Justice Corliss was on the court, and we had Justice Martinez and Justice Malarkey and Justice Scott, Justice Hobbs. And actually Justice Volokh. You know, we talked about things in a way that were very, very collegial, and it felt very good. I've heard at least Corliss and Martinez refer to it as the happy court. You know, I've been very lucky and very blessed, and I really, when I'm on the losing side, I might get a little angry or something internally, but it's a great honor to be there, and I'm most of the time quite happy. I have a lot of good memories about it.
That's good. So I want to be sensitive to the time and the fact that we have food and drink that we hope everyone can share, but you mentioned a few minutes ago that you hoped that you would have more great experiences in practice.
Sure.
So
I'm looking for a job. So.
Is anyone here hiring? What are, other than whatever your job might be, or including whatever your job might be, what are the things you look forward to in the next decade?
Well, I look forward to doing some mentoring. I look forward to trying cases on both the appellate level and the trial court level, solving problems. I like the practice law. I really never, I always enjoyed being a lawyer. I didn't choose to try to get to be a justice because I hated what I was doing. So I look forward to doing more of that. I think that there's a certain amount of satisfaction that I get from dealing with people's problems and trying to solve them. And I think that's what lawyers fundamentally do. Whether it's transactions or litigation, people are coming to a lawyer because they can't solve their problems. And they're looking for some sort of solution, and you're trying to do that. And sometimes you can do it, sometimes you can't. But I like the process, and I feel gratified by it. That's what I look to get out of it, and I wouldn't mind making a few dollars at the same time. Does the audience have some questions? Or?
Oh, yes.
We'll see if anybody's got any.
Morris Sandstead, all right.
Mo.
I think
You got to speak up, Mo.
We're bringing a microphone over.
Yeah, this guy needs a lot of help.
Bellow it out, Mo.
I'm going to ask you the same question I once asked Tony Volokh while I was still on the bench, and he was a visiting judge in Boulder. And I came across him, he was just standing in the hall, and I said, I think I called him Justice, but I might have called him Tony. But I said, and I want you to answer the same question. I said, Justice Volokh, I said, I've been on the bench for many, many years. I've been reversed many, many times, and it never, ever bothered me. I just did what I thought was right, and it never bothered me. But you, him, Tony Volokh, wrote an opinion on the parole evidence rule, and
Yes.
you are wrong.
Yes.
So what was his answer?
What was that?
What do you think his answer was?
Geez, I don't know.
Well, he said, Mo, you might be right. Would you give the same answer?
Absolutely. Except for the one I wrote a dissent on Terry's opinion, on the prior restraint.
Other questions from the audience? We have a microphone that can travel.
That's right. A traveling mic.
Professor.
Phones.
This is a broad question you have to pick part of. And it's comment on the
A, B, or C?
the system for petitioning to amend the Constitution and for the job of interpreting the products of that system.
Start that again, the petitioning?
The system that we have for amending the Constitution by citizens petition followed by popular vote.
I'm going to pick part that one when I'm done on January 8th.
I was going to say.
But not before that.
That might be.
There is a lawsuit pending, and I'm sure you know about it, Rick, which challenges under the guarantee clause the Republican nature of the Tabor Amendment.
But
And-
not of the initiative system, more just
No,
justice.
no, I mean, it's, well, I mean, you know, got to start somewhere. But that's right. Yeah, the guarantee, so, but I have clear views on that one, but I'll wait until I'm out of here.
Loaded. Anybody else? Yes, go ahead.
This question may be irrelevant because I'm not sure if it's even allowed in Colorado, but if the Supreme Court were to allow former justices to come back to deliberate if they had someone retiring, would you be interested in doing that?
Say this again, would I want to come back?
If you could.
If
Well, if you're asking me would I quit, the answer is no. I really love being chief, and I like being a justice. But everything in life, you know, there are chapters. And so 16 years and 11 months and whatever it is, a couple of weeks is adequate. And I've had my fill, and so I got to do something different.
okay, thank you.
Is that what you meant?
Not exactly.
About
What did you mean?
coming
I didn't
back?
quite get- I
Coming
didn't-
back as a senior justice? Or?
There's no such animal.
Well, I know there's no such animal.
There are in some jurisdictions, but I could be a senior judge like Terry is, which I have no desire to do.
Okay, thank you.
I wanted to ask you a question about what you like to do in your spare time. Those of us who know you know that you probably work 18 hours a day, but
Well,
I've seen you in that other capacity.
Yeah.
There are some times when you
well, sure. I
like
like
to
this.
enjoy
We have a
it.
place in the mountains. I like to hike. I like to ski. I like to bike. I work out every day. I watch a lot of sports. My wife, you know, watches soap operas, and I watch sports.
What's your favorite ski area?
Breck. Although I'm like in Monarch now, because I have a place down there. But, you know, I enjoy doing that. I think that I'd be very bored doing nothing but that. I would not be a happy camper. Years ago, when I was still a little bit hippified, I was a public defender. I've been a lawyer about 8 or 9 years, and I did a little photography, and it was before digital photography. So I just thought, well, I'm going to give up this law business and be a photographer. And so I had a 2-week vacation, and so the first week, all I did was either take pictures of things and people, or work in the darkroom, and I hated every minute of it. Because not because of the photography, but because I was not dealing with people. You're very lonely. As a photographer, you're a spectator. In the darkroom, you're sort of an artist, kind of manufacturing something. You're not really relating to people. So I learned my lesson about me. It wasn't an intellectual thing.
Well, I think that we should, no one's allowed to actually leave the immediate vicinity. We have food and drink right next door in Betcher Hall, and I think we can continue this conversation as a conversation.
Okay.
And thank you so
Well,
much,
thank you.
Chief, for being here.